Welcome to the Distressed Business Playbook.
Welcome back to the Distressed Business Playbook with attorney Todd Duffy, founder of Todd E. Duffy PLLC. Todd is a New York bankruptcy attorney who works with businesses and decision makers navigating financial pressure, restructuring, and complex legal challenges. I'm Evan Mack, and today we're talking about what happens when financial problems turn into legal battles in bankruptcy. Todd, welcome back, sir.
Thank you. Thank you for having me.
So, Todd, what does bankruptcy litigation actually involve, and how does it kind of differ from the restructuring side of the case?
So the restructuring side of the case talks about how you're going to pay out your creditors. It talks about it. You're trying to create a plan and a scenario where all of your creditors are going to get paid. Generally speaking, litigation involves one creditor, maybe two. And it comes in three different flavors usually, although you can move state court litigation over to federal court because you're in bankruptcy court. You can have what's known as avoidance actions, and those come in two flavors. One is a preference action where you've actually paid one creditor over another, which is you've preferred one creditor. And the other is a fraudulent conveyance where you've given something that's of higher value for less money than it's really worth. That generates money for the estate, and so then what you do is you take that money from the estate and then you use that to pay creditors.
So what tends to push a situation from a financial problem into an actual legal dispute?
Well, generally speaking, let's take preferences, for example. In those cases, creditors are generally chasing debtors, and they've been chasing them for a while, and they finally got the debtor to pay. And they're excited because after chasing these people for sometimes years, the debtor finally paid its debt and they're finished, but they're not. They think they're finished, but they're not finished because the debtor turned around and said, "I want the money back." Well, and to most people that would seem unfair, right? I mean, he was owed the money, but bankruptcy thinks about things a little bit differently. So when you file for bankruptcy, you're talking about an entire creditor body. You're not just talking about one creditor. So those creditors only got 50% of their claim, but you got 100% of their claim within 90 days of the filing. And on their plan, they're only getting 50 cents on the dollar. It's not fair for you to get 100 cents while these creditors are only getting 50 cents. So what happens is you have to pay the money back, and then you get the same 50 cents that everybody else gets. And that levels the playing field.
What kinds of disputes tend to come up most often once a business is in bankruptcy, though, Todd?
I think generally, if you have a lawsuit going forward, if you have a lawsuit in outside of the bankruptcy court, some cases you may want to bring it into the bankruptcy court because as a debtor's counsel, that's going to be a more favorable area for you and for your client. I think the other reason, the other things that could come up is it depends upon the nature of your relationship with the creditor. And I hate to sound kind of like a lawyer, but the truth is that when you start a bankruptcy, you sort of have an idea of how you want to get out of that bankruptcy. I think most good bankruptcy lawyers come into a case and know sort of what they want to do. But as one of my first mentors used to say, it's battlefield conditions. And so you have to be flexible enough given what happens on the ground to change your plan. And you have to be able to come in and, deal with conflicts and diffuse conflicts quickly, but see how each conflict affects the financial wherewithal of your client.
How do the different players in a bankruptcy case start to pull in different directions once litigation starts to be involved?
Yeah, so I remember when I first started practicing and I was training at a very large firm, I learned very quickly that you can be at someone's throat very quickly, and an adversary's throat very quickly in a case. And once you've resolved it, they could be your best friend the next day. Most of what bankruptcy lawyers do is not about fighting. It's about making deals. And so litigators, everybody thinks of lawyers going into court and fighting. And it happens. And I'm not saying bankruptcy lawyers are saying kumbaya in court or anything, but what we tend to do is we tend to make deals much quicker. There's usually an initial show of strength by showing the other side that the law really does bend in our favor. And then once we've really established that you usually pick up the phone and you call the other side and you say to the other side, let's do something, because if you don't do that, then the debtor dies. The business will die the longer that it's in bankruptcy. And if the bankruptcy is in long enough, the courts get very annoyed at the debtor's counsel for not moving things along. And and it tends to convert to a Chapter 7. So everything is liquidated and your client has lost his business and lost all control over everything. In some cases, that's success because they don't really have the wherewithal to pay their creditors a significant amount. And, they now can go on and start a new business if that's what they want to do. But in other cases, when you can negotiate a great deal with a predominant creditor, then you've now not only helped your client, but you've rebuilt their business for them. And it's a really wonderful feeling as a bankruptcy lawyer. Really, that's my favorite part of being a bankruptcy lawyer.
What changes once a dispute becomes, formal litigation inside this bankruptcy case?
It's harder to make a deal when you're in formal litigation, I think, right? You want to try and tackle this before somebody files a complaint in bankruptcy court or before they remove, if the litigation started pre-petition, of course, there's not much you can do about that. And when I say pre-petition, I mean before the bankruptcy was filed. But the longer the litigation goes on, the hardened everybody's positions become. And so it's harder to make a deal once the litigation has drowned out because everybody's counting the amount of money they've had to spend in order to get to this point to begin with. And that always takes away from their evaluation of a good or a bad settlement offer. So you have a $1 million debt or a $1 million case in controversy, but you've spent, $600,000 trying to get to this point. There's only a $400,000 differential, and they're not only looking to recoup their $1 million, but they're also looking to recoup the $600,000 they've spent in legal fees.
Wow.
It's a lot of wheeling and dealing and knowing. And I think that a lot of it is gaining the trust of my adversary. The bankruptcy, the Chapter 11 bar is a fairly small bar, and everybody really pretty much knows everybody. And if you have worked in this field long enough, you get a reputation, good or bad. And in fact, I was up in front of a judge yesterday for a client, and there was an issue about something called exclusivity. And the judge said to me, Mr. Duffy, what do you think about exclusivity? And I said, exclusivity is over, Your Honor. The debtor no longer has an exclusive. I represented the debtor. I said, the debtor no longer has exclusivity to file a plan. And that means that any creditor could file a plan of reorganization instead of my client. And I would have to either deal with that plan or file my own to compete with it, and people would vote in favor of it, and then we'd have to count. But I had to be honest with the judge, even though that wasn't what was the best interest of my client. I'm sorry. Being honest with the judge is always ultimately in the best interest of my client, even though what I had to say was not what my client either wanted to hear or wanted to be the reality. But that's my job as the lawyer. I have to keep my credibility up with the judge in the court, and I have to be able to deal with my adversaries. I can't do that if I'm not honest and straightforward.
So how do these disputes, affect the broader bankruptcy process or the business's ability to, move forward?
So it's harder for the business to move forward in bankruptcy. But I would say that as a debtor within a Chapter 11 bankruptcy, the business continues on as if they are not in bankruptcy. The client is called a debtor in possession. They are in control of their own assets. They run their business just like they would beforehand, with the exception of things that are outside the ordinary course of business that they don't normally do, they need court permission to do. But anything in the ordinary course of business that they normally did, then they're going to do in bankruptcy. It makes it harder to grow the business because you always have to get court permission and because it takes time. And it makes it, if you're in a service field and people hear about the bankruptcy, there could be a bit of a stigma. The way that I explain to the client about how to deal with that stigma is I would much rather deal with that stigma than lose my business. Because if the creditors are chasing you and you're already in a position where you're being strangled, Bankruptcy gives you that moment gives you that time to negotiate and the leverage to negotiate with your creditors and to rehabilitate that business. And it's your best shot. It's not infallible, but it certainly is your best shot.
So do you have a story or maybe a situation where a bankruptcy case turned into a significant legal battle and how that ultimately played out?
That construction case I mentioned earlier
Yeah.
had one creditor who was litigating against the client in district court. And I was appearing in a district court is the next level up. And so I had to run to district court in between running to bankruptcy court. And um, I was in, I was constantly in contact with my adversary, whom I fortunately had known for a very long time. And he not only is he a good lawyer, but he's a good person. And so um, I had proposed several deals where I thought, um, that we could find a resolution and get everybody paid at somewhere close to 100 cents on the dollar over 5 years. He was not, his client was not really thrilled with that deal. And
Hmm.
so um, at the end of the day, there was so much litigation going on that I watched the client and I could tell that the client couldn't possibly grow the business, couldn't work, couldn't function. Why? Because he's busy with all the legal responses and discovery and all kinds of issues that came up in the bankruptcy in order to maintain the business in bankruptcy. And although we had a plan of reorganization already written without a deal from that creditor, there was simply no way to get that plan confirmed. And so what we decided was best for the client was to convert that case to a Chapter 7, which meant there was a Chapter 7 trustee who came in and he was able to look at the assets, calculate everything, do an investigation, and then the business was basically wound down. Um, and because I represented the business, I couldn't represent the principal personally. And so I reached out to a colleague of mine because there'd be an unethical conflict of interest. And so I reached out to a colleague of mine and she represented him very well.
Mhm.
And so uh, that's my story. That's what happened. Sometimes success is that he got out from under those bills, just not in the way that he wanted to.
Right.
And it's not, it's never exactly the way you envision when you walk in, but, you hope it's better. My preference would not be to liquidate in Chapter 11 or Chapter 7, but it certainly was that was the best outcome for the client.
So where do business owners underestimate the risk or complexity once litigators enter the picture?
I think that generally speaking, that it shows up when they wait too long. When all that animosity builds up, when everybody's thick and hardened and they don't really want to make a deal, all they want to do is fight. And, I've had more than my share of cases like that, but that construction case is a perfect example of that. They had been fighting for years over
Mm.
that particular debt, and it grew over interest and everything else. And it got to the point where there were all kinds of personal accusations made back and forth. And, the best part about having a lawyer there is that they could be a buffer zone to that. And especially if the lawyer on the other side is a good person and that you've known a long time, you can pick up the phone and call the guy and say, "What are we doing? Like, this is crazy." And they are it and I most of the people I know in the bankruptcy bar are very much receptive to that kind of call. So it's very helpful for the client. Even if the clients are at each other, the lawyers aren't. And the lawyer that allows the clients to actually work for a solution to put this behind them.
So Todd, to put a nice bow on this, what separates disputes that resolve efficiently from those that turn into long, drawn out fights?
I think relationships, in a word, right? I think the relationships that you have with other counsel,
Right.
if you can bring it in mediation, the mediator would help that. You need a third party who is involved in the transaction, who can, speak sanity to these two parties who, if they're not listening to their lawyers, then maybe they'll listen to a mediator or maybe they'll listen to the judge. There have been times that I've asked that a colleague of mine and I have asked the judge to pull us in and help mediate this because we just couldn't get anything. Um, I once represented a client in bankruptcy court, not because the client was in bankruptcy, but because there was a very old bankruptcy and the client had attained a settlement with three other lawyers, and they wanted to screw him out of his share.
Ooh.
And so I filed a litigation in bankruptcy court, and I litigated it for not long, probably 6 months,
Wow.
and got everything we asked for. We weren't pigs about the whole thing. We just wanted an equal share, and they
Absolutely.
made up a story about how he agreed to do something, but of course they didn't have it in writing. And I had an email that said, "Well, this is why this happened," and the judge believed me, and so she entered an order giving us exactly what we asked for in the complaint. I think part of it, and I've known that judge a long time, I think part of it was that we weren't trying to be pigs. We're just
Yeah.
trying to get our fair share.
Yeah.
And it builds that kind of credibility to show a judge that you understand the law. You're not trying to take advantage of anything. You're not looking for an opportunity. You just want what you believe you're owed.
Absolutely.
And if the only thing at that point the judge will say is my client is owed it or not. When you're a lawyer, you always stand in the shoes of your client. But but that's really all there is to that.
Good stuff. Todd, great stuff.
Great. Thank you.
All right. That's it for today's episode of the Distressed Business Playbook. If you'd like to learn more about Todd Duffy and his work with businesses navigating, restructuring, and complex bankruptcy matters, visit teduffylaw.com. Thank you so much for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. We'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.